Hey out there, legal warriors, arraignment. What is arraignment and why do so many lawyers waive arraignment? Is that a good idea? Is it a bad idea? What's in it for you and why does the court even allow such a thing? If you're interested in the criminal law, if this appeals to you, please stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now just jumping right into it. An arraignment. What is it? What happens in an arraignment? And why do so many lawyers waive arraignment? And is that a good idea? So an arraignment. An arraignment means that somebody's been charged with a criminal complaint, a crime, and they've been summoned to go to court. And that first court date after a formal charge is called an arraignment. Now, you can get arrested without being formally charged, and we have a lot of videos on that, but basically, if you're arrested for a felony, you're not going to get arraigned right away because a prosecutor's got to determine whether or not to file a charge. And if you get arrested for a non-felony by a sheriff or a state patrol officer, typically you're not going to get arraigned right away. Either that first court date in those cases is a first appearance. So I'm talking about some person who is actually charged with a crime by a city police officer by filing a criminal complaint themselves. That's what city police officers can do on non-felonies, or a complaint that's been signed off on by a prosecutor. So that first court date, the arraignment, is where you go to court and the judge says, hey, defendant, have you received a copy of the complaint? If not, here's a copy. And do you want me as the court to read it to you, or do you waive a reading of it? Which means, do you want the court to read you every element in the complaint or not? Usually it gets waived, the reading, and then they ask you to enter a plea of not guilty. And then what happens in arraignment when the defendant enters a plea of not guilty is there's a prosecutor who gets to ask for conditions that the defendant has to live up to while the case is proceeding through prosecution. And those conditions can include bail, where you have to post money to stay out of jail. They can include like having to put on an alcohol monitoring device, either a scram device, like the Lindsay Lohan bracelet you get to wear on your ankle to see if you drink, or you might get ordered to blow into a sober link device where you have to blow to see if you've been drinking. Or even worse, the court might order you not to go home or to have no contact with your family or the alleged victim. All types of bad things can get ordered against you at an arraignment. An interlock device can get ordered on you, and for a DUI type case, GPS monitoring can get ordered. I mean, the list goes on and on. The best thing that can happen at an arraignment, as far as conditions, is the prosecutor to say, hey, standard conditions, no crimes, keep us informed of your address, and stay in contact with your defense attorney. So the court hears what the prosecutor wants to have entered, and then the defense gets to argue, and then the judge, the court, sets the conditions and then sets a court date. So, we don't get to argue the case there. There's no defense that gets presented. It's basically the court finds probable cause and sets conditions, and then we go on to court dates. So that's what happens at an arraignment. So maybe you can already guess why it is, from what I've told you, us attorneys want to waive arraignments when we can. It's because if we waive the arraignment, then we totally skip over all those chances for these really bad conditions to get set against our client, right? If we waive the arraignment, if we're allowed to, the court can't put bail on you. The court can't order you to do anything because we waived it. Now, later on at the next pretrial hearing, the pretrial hearing after the arraignment, if arraignment was waived, the court does get a chance to address conditions then, but the secret is by then, people don't care as much. It's a month or two down the line, you've had lawful behavior, prosecutor may not even be thinking about it. So it's a good idea to waive arraignment just for those practical reasons, because it's going to avoid a bite at the apple to get bad things ordered against you. Now, when can an arraignment be waived and when can't it be waived? Well, as you might imagine, the legislature has set several categories of crimes where the court is required to hold an arraignment to set conditions against the defendant. And the major categories are DUI type charges, DUI or a physical control, physical control is sort of like a DUI without driving. The court's required to have an arraignment. You can't waive it there. And also on domestic violence charges. We're not allowed to waive an arraignment on domestic violence charges because the court has to have an opportunity to protect the alleged victim, whether they want protection or not, by entering no contact orders, stuff like that. So we also are not allowed to waive an arraignment on felony matters. Felonies are so serious in the eyes of the legislature that we're not allowed to waive that arraignment. We're going to have to go to that arraignment. And depending on the county, if you're in King County, there's some really, really difficult conditions often get set. And in other counties, usually they're a little more reasonable. And that has a lot to do with timing. But the bottom line is, the quicker you're in front of the court after the allegation, the more harsh the conditions might be because it's fresh in time. It's human nature. The longer it's been before you're in court since the allegation, the less strict typically we're going to see for the conditions. So what are some other reasons we want to waive arraignment? Well, number one, it's going to be less stressful on you, right? You're not going to have to miss work. You're not going to have to find childcare to go to court. You're just not going to have to do any of that, right? You're just going to be told by your attorney what the next court date is. Also, by waiving arraignment, it also delays things. And like I mentioned, delay is typically good for defendants. If it's a case involving alcohol, like a theft case where someone's accused of stealing alcohol or something, we waive that arraignment. Well, maybe we get them an alcohol evaluation before the pretrial. Maybe we get them into an alcohol class before the pretrial. Maybe we settle something with the store before the pretrial. So you come to the court for the first time with a better opportunity to be in a better position, right? And to look better for the court and the prosecution. And let's face it, that's what we want to do. We don't want to have to get into an argument about the facts of the case because there's going to be a police report that's written by a professional who took a side totally against the defendant, right? So we want to do what we can to put anyone charged with the crime in the best position they can be the first time they're in front of the court. So how do we waive an arraignment? Well, an arraignment is waived by the attorney filing a notice of appearance saying, hey, I represent the defendant, and we also waive the arraignment under the court rule. And there's court rules that say how it's done, but we have to serve the prosecutor, and we have to serve the court. Then hopefully your attorney is going to be checking the court docket or checking with the court to see if the court has agreed to waive the arraignment. There are some local court rules for each court, and some of the more rural courts have different rules, in my opinion, sometimes. So not every arraignment that is waivable under the general court rules is truly waivable in a specific court because each judge has their own way of doing things, right? If there's a case with the discharge of a firearm, the normal court rules could say we could waive that, but a sitting judge might say, I don't want that waived because I won't waive arraignments for guns cases. I want to set some requirement not to possess a gun. So your attorney needs to check, to see if the court's accepting the waiver of arraignment. And sometimes the court will accept it and issue a new court date right away. And then usually our firm would let the client know when the court was. Or sometimes the court will wait until the actual arraignment date and process the waivers as they would normally come up on that arraignment calendar. So a waiver means that the attorney signs something saying, I'm the attorney and we're going to waive our right to an arraignment because it really benefits us. So I hope that makes a little more sense. If you find this useful, please like and please subscribe because more people will get to see it. And if you got a criminal charge in Washington State and you need some help, feel free to give my office a call. My law firm's been doing this for more than 20 years. We'll pick up that phone, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.